How can you tell that the ambiguous term residential school denialism has gotten out of control in Canada? Perhaps when a criminal and their lawyer go to the highest of courts to try and appeal a conviction based on allegations that the sentencing judge is such a denialist because, get this, that judge corrected the false claim that there had been remains discovered in unmarked graves at the former Kamloops Indian Residential School in British Columbia. Let's talk about it. Drea Humphrey here with Rebel News, and this is Miranda Dick. She's one of 8 self-proclaimed land defenders who were charged with criminal contempt in 2022 after being arrested for intentionally obstructing the safety and construction of the Trans Mountain Pipeline and thus defying an injunction. In 2023, a Judge Shelley Fitzpatrick sentenced 6 of the 8 to jail, and Dick, as well as her father, who is a Secwepemc hereditary chief, were both sentenced to 28 days of imprisonment. The Secwepemc's banned governments include the Kamloops Secwepemc First Nation. Most of you recognize that banned government as it became a household name of sorts in 2021 after making the sensational claim to have confirmed the discovery of the remains of 215 children who were former students of the Kamloops Indian Residential School buried in unmarked graves. Except here we are. 3 years, 100 burnt and vandalized churches, and $7.9 million tax dollars given to that nation for the discovery later, and the reality is not a single body has actually been discovered there. But reality isn't always a strong suit for social justice warriors who cry racism to, deflect from poor decisions, and apparently also not from social justice lawyers who actually think doing so is a good criminal defense. You see, despite serving her time, Dix decided to try and appeal the conviction, whether it be to set a new legal precedent or pursue compensation for wrongful conviction, I'm not sure. But what's berserk about this appeal is the primary reason her and her counsel submitted for bringing it forward. Here's the BC Court of Appeal's reasons for judgment, which was handed down late last month but only recently brought to my attention. Chief Justice Leonard Marchand, who, by the way, is Indigenous and grew up in Kamloops as well, and 2 other justices presided over the matter. At the top, it summarizes Dick's argument here that a comment made by Judge Fitzpatrick at the sentencing hearing relating to potential burial sites discovered at the site of the former Kamloops Indian Residential School gave rise to a reasonable apprehension of bias. But how could a judge stating the truth prove a bias? As I pointed out in my investigative documentary called Kamloops: The Buried Truth, which debunked the 215 buried kids claim on its 1-year anniversary, even the ground-penetrating radar specialist Dr. Sarah Bollier, who for some reason confused most of the world into thinking it's even possible to prove human remains lie beneath the soil without excavation, backpedaled from her initial claim weeks after.
From my preliminary findings in May to today's results, reports providing additional information related to disturbances from archaeological impact assessments, as well as construction in parts of this area, were subsequently provided to me. These reports were reviewed in order to determine which of these locations overlapped with the GPR survey areas. After this review, it was determined that there remain 200 targets of interest in these preliminary results.
200 anomalies, targets of interest? That's not even saying 215 buried Indigenous kids, is it? In fact, it's not even definitive between the potential findings of human remains, tree roots, or, as we've reported on before, potentially an old sewage plot. But I guess Dick and her literal social justice environmental lawyer Benjamin, who has a slew of other credentials, none of which helped him to come up with a good defense here, were not up to speed with much of the facts when building the case. Here's an excerpt from the transcript of the sentencing proceedings where Judge Fitzpatrick made the alleged racist and biased comment during an exchange with Dick's counsel. Izzet was giving submissions regarding a Miss Bibbings, who was also found guilty of the same offense. During those submissions, he starts describing places Bibbings had worked and volunteered, including what he describes as 215 healing forests to honor the Kamloops Residential School children whose bodies had been unearthed. Like a wise judge should do, Fitzpatrick intervened for accuracy in the court and said, there's no bodies that have been unearthed. Isit replies in ignorance. Remains. Remains have been unearthed. Judge, they have been? Is it? Oh, sorry, I stand corrected. Who have been identified through ground-penetrating radar. The judge further clarifies for the court by stating potential, as in potential graves, as in the truth. How embarrassing that must have been for the defense. But can you really blame him at that moment? I mean, even before my documentary, my initial report, just days after the 215 claim was declared as a stark truth, I made sure the public knew that it wasn't possible to conclusively identify bodies solely by GPR. And while I get labeled a residential school denier for stating such facts from ill-informed social justice warriors like Monique May, who recently tried to have me canceled from speaking at an event,
one of their speakers has done many documentaries to debunk residential schools in Kamloops.
State-backed media journalists who have effectively pled the fifth on the facts about the Kamloops band's claim and failed to transparently correct the record, on the other hand, continue to allow activists like May and Miss Dick to be consumed by moral panic and spew off baseless claims because of it. States media's omissions also help fuel the mass hysteria that's led to attacks on Christian places of worship and emboldened powers like independent special interlocutor Kimberly Murray and the NDP's Leah Gazin to go on their modern-day witch hunt seeking for criminalization of those they deem to be engaging in violent residential school denialism. Who knows, perhaps they'd like that to include Justice Fitzpatrick. But it's not just Dick and her lawyer who were clueless about what hasn't been discovered at the former Kamloops Indian Residential School. Apparently, it was also a good portion of those who were present in the court gallery during that exchange as well. Here in the transcript, it says that after Fitzpatrick made those clarifications, there was an outburst in the gallery and accusations hurled that the judge was a racist, to the point it got so bad that some gallery members were removed from the courtroom as a result. What an absolute disgraceful circus. Who knows, maybe some of those who were part of the uproar were among the group of allies who started to crowdfund for Dick's appeal, while labeling Judge Fitzpatrick an openly anti-Indigenous judge. Now, I know I offered the excuse earlier that state choice media is a key reason why Dix and her lawyer Isit may be in the dark about this, but that excuse doesn't really fly when it comes to actually using that exchange as some sort of legal defense for an appeal. I mean, you would think that after the judge made such corrections, a good lawyer would have really done his own research, done some digging, maybe bypassed the propaganda and stumbled upon my documentary at kamloopsdocumentary.com, which is now available for the public to watch for free, and then talk some sense into his client. But that doesn't appear to be the case. Instead, Isit stood before the BC Court of Appeal with a straight face to submit Dick's insulting stance that Judge Fitzpatrick use of the word potential modified the word remains, and that she conducted herself in a dismissive attitude with intolerance and worse, outright denialism. Dick's exact position was that the inference reasonably created by the judge's comments, that allegations of Indigenous children being buried in unmarked graves at the Kamloops Indian Residential School were false, fabricated, or otherwise untrue, lacked a reasonable basis in fact of law and demonstrated an intolerant view that's inappropriate for a judge presiding over the sentencing of an Indigenous person, particularly in common law contempt proceedings for the child of a residential school survivor occurring a few kilometers from the Kamloops school grounds. So what did Chief Justice Marchand say about this madness? I've put his full reasons in the written article for this report, which you can find in the description box below, but for now, I'm happy to report that while the Chief Justice did entertain the claim that residential school denialism is a real thing, even though no one in their right mind is going around denying that residential schools existed or even that some bad things occurred in that system, Marchand did dismiss Dick's appeal. He said that Judge Fitzpatrick clarified and corrected defense counsel's inaccurate submissions that human remains had been unearthed at the site of the former KIRS school. and that the word potential that caused uproar and hurt is the very same word Indigenous communities and others have used to describe the results of tests using ground-penetrating radar in and around former residential school sites. He gives examples of how the words potential, possible, and suspected unmarked burials are also repeatedly used in the 2023 interim report of the Independent Special Interlocutor for Missing Children in Unmarked Graves and Burial Sites, which again is Kimberly Murray, adding that it is simply not possible to objectively interpret the judge's comment about potential remains at unmarked burial sites as indicative of apparent or actual intolerance, denial, or bias. Chief Justice Marchand also rejected Dick's secondary defense, which accused Fitzpatrick of failing to give proper effect to Gladwell principles, which is essentially saying that the judge failed to implement a series of guidelines within our Canadian law that's there to address the disproportional amount of Indigenous people in the justice system. To that, the Chief Justice said that the judge's reasons demonstrate she took guidance from the code in Gladue, considered the role played by systemic and background factors in Miss Dick's offending, identified the primary sentencing objectives, weighed the relevant sentencing principles, and imposed a proportionate sentence. Marchand concluded that although he did grant the appeal to be heard, the appeal was ultimately dismissed. I'm glad some sanity returned to the courts, but let me know in the comments your answer to the following question. In a country where a distinguished judge can be labeled a racist, a denialist, and actually have their sentence heard in the appeal courts for simply correcting misinformation swirling around about unmarked grave claims, would a Chief Justice who wasn't Indigenous have felt at liberty to hand down the same decision? Drea Humphrey with Rebel News. As you can see from this report at Rebel News, we don't back down from bringing you the other side of the story, even if that means people try to cancel us, or even worse, threaten, or sometimes get violent with us. That's why we take security so seriously here at Rebel News when we're out in the field. And if you appreciate our reports, please consider helping us recoup some of the costs and the future costs of keeping me safe while I bring you reports. You can do so at our special website called protectdrea.com. We appreciate your support.